This is Mark Kemp of LasVegasProbateGuide.com with your 2-minute probate tip. On a prior video, we mentioned that joint tenancy assets do not have to go through probate. They are simply claimed by the surviving joint tenant. The thing you need to understand, though, is that under the law, there's a thing called tenant in common. That's where property is co-owned by two people or more, and it does not have the right of survivorship feature. So a good example would be this story. I once had a mother who had two sons, and her first son died. So her second son came to mother and said, "Mom, we need to put me on the title to your house because when you die, I don't want to go through probate." So what mom and son did is they created their own deed that mom signed that took the title to the property from mom to mom and son. And that's all it said in the deed, mom and son. So then when mom's second son died before her, and she came to look at the title of the property, she discovered that it wasn't held in joint tenancy because it didn't say mom and son as joint tenants, it just said mom and son. That meant that the half of the property owned by son that mom had given him did not go through probate and end up back with mom. It went through probate and ended up with her son's chosen heir, which in this case turned out to be son's wife. So now mom owned her house 50-50 with her daughter-in-law. Mom was not happy. Another example was on a car title. In Nevada, when you fill out the box on the car title, they have a check the box for or, and they have a check the box for and. So you can put two names on the title to a car, but if you check the box for and, the Department of Motor Vehicles doesn't treat it like joint tenancy. They treat it like the first person who died, their property needs to go through probate, their half. Only the survivor's half is owned by the survivor. So you need to be careful when you're looking at these documents to decide, is it in fact joint tenancy, or is there in fact a tenant in common interest that needs to go through probate?